appellant. I assume you've already reserved your time.
3 minutes, please, Your Honor.
You may proceed.
Members of the court, Michael Kelly of the Blount County Bar and the Knox County Bar. I have with me today my law partner, Elizabeth Peterson, who is, this is her first time in this court. Previously, she was a law clerk for Federal District Judge Corker for 2 years. She provided substantial assistance in the research and the brief. And so if there are mistakes that are made, they are mine. If there are incredibly insightful turns of phrase in the brief, she gets credit. So thank you, Elizabeth, for helping me so much on this brief. Members of the court, we have a number of issues that we've raised in our brief. There's not sufficient time to go through the 3 of them, but I want to focus on, or go through all of them. But I want to focus on 3, all of which relate to the distribution of property in this, as a result of this divorce. The 3 issues are, 1, whether certain assets are even owned by either of these parties and subject to the trial court's distribution. The record shows that a herd of cattle were the property of Mr. Hill's mother, Judith Hill. The parties moved to require her to be joined. The trial court ignored that. Then at trial, when she testified on her own that they were her cattle, notwithstanding the obligation to join a party that has a property interest under Rule 19, the trial court took no action whatsoever. And if the court actually looks at...
Did she actually make a request to be joined, or was the request made on her behalf?
Your Honor, the request was made by each of the parties. It's not a requirement that she make the request. And in fact, what was, as someone who is new to this area, I was perplexed and amazed that when I found an opinion of former Court of Appeals judge, now Justice Kirby, that indicated that even if the parties don't request it, that the trial court and even the Court of Appeals is obligated to go no further and make a determination that a party should be joined.
Does it ultimately matter, though, given that she testified, and I mean, her testimony came in about whether she owned the cattle or not? So what does having her as a formal party do for you?
Well, it affects the ultimate outcome of the distribution of the estate. If those assets, which we say were her assets, should never been a part of this case and never been a part of the distribution. Furthermore, she has independent rights. She has a right. At this point, what we have is my client, there's been adjudication that he has an ownership and that the appellee has an ownership interest in this assets. What are they to do with them in light of the fact that there's testimony that Ms. Hill has an ownership interest? Well, can he sell them? Is she not going to have to file a separate lawsuit to adjudicate property interests? That's the very purpose of Rule 19, that if anybody is affected, they have to be joined. And here, she testified as a witness, but there was no advocate on her behalf. There was no lawyer there. There was nobody pushing her interest. And if the court looks at the trial court's opinion, there's no mention in the discussion of cattle that Judith Hill even has any part in it. Until reading we were not trial counsel, so until reading the transcript, we didn't even know that she had an interest. So that's a fundamental error that started this distribution in the wrong way.
Did the court make a finding of fact? Who owns the property?
The court's finding of fact was that it was marital property that was owned by the husband, and there's no mention whatsoever of Ms. Hill, who was never joined as a party. So that would be a reason for the court absolutely to send this back for that proper adjudication. The second area, and candidly the most fundamental mistake that the trial court made, was not looking at the statutory factors that are...
Excuse me for interrupting. I'd like to digress back to this motion for joinder. As I understand, the court's ruling with regard to that motion for joinder was that that motion was filed prematurely. Is that correct?
That's right. Correct, Your Honor.
When that motion was filed, did that motion request joinder for the purposes of adjudicating a classic car business, or did it also specifically reference an adjudication of issues involving real property, the metal building, as well as the cattle?
I think the court's clearly read the record, though. That specific motion only, if I recall, only requested the joinder related to the metal building. But I don't think, and I agree, I mean, my first thought was, well, has my client waived that issue by not bringing it up? But again, the Court of Appeals opinion from Justice Kirby says that's candidly irrelevant where we have evidence at the trial that someone else owns this asset. All that the court had to do was to recess the trial, require her joinder for that one issue. It's a multi-factor trial, and reset the case for trial, giving her an opportunity to adjudicate it. So if we had an issue, if it wasn't for that, I would say that issue was waived. And
When the trial court made the ruling that that motion for joinder was filed prematurely, was there another motion filed?
No, Your Honor. No, Your Honor. Not to my knowledge.
So your client's position is that that was not waived, that motion under Rule 19?
Correct, Your Honor. Because of what the Court of Appeals has said in terms of what came in as proof of the ownership interest.
Thank you.
I think the most fundamental issue here, Your Honor, members of the court, is the issue of those statutory factors. This court in the Kirby case, which I think was an opinion written by Judge Frierson in, I think, 2016, focused on the fact that although discretion, there's a great deal of discretion given to trial courts in terms of making equitable determinations, it has to be based on, the statute says that it shall be based. This is 36-4-121C. In making an equitable division of marital property, the court shall consider all relevant factors, and then lists now 13 separate factors. And in the opinion, as in several recent cases of this court, one arising from Chancery Court here in Knox County at Judge Pridemore, the Dalali case in 2020, and there's several others we've cited in our brief, there is nothing there whatsoever about those factors in the trial court's opinion. The court went through the various properties that were at issue, the house, the cars, the assets in the wife's retirement account, but nowhere does the court even cite that provision, much less go through and identify how those equitable provisions play. In our reply brief, in fact, Your Honor, members of the court, we went through and identified the ones where there had been no finding, no reference whatsoever. And I did that because to give Appellee's counsel absolute credit, what they did in response to our argument was to scour through that opinion, identify the ones where there had been some reference to something, for example, the husband's employment status, the wife's employment status, and say, well, the trial court didn't go through that process, but in fact, you see this reference. Well, that's just inaccurate, because even in the category where we're looking at things like the husband's employment status, the wife's employment status, age, those all were discussed solely in the context of child support, which is a completely separate and distinct evaluation. What should have happened is the court should have gone through all these things, and having made the determination of whether they are marital or separate, looked at that collection of assets that was determined to be marital, and then applied these various factors. I'll show you the ones just to reference the factors. There was no discussion of C3, no discussion of C4, no discussion of C6, no discussion of C7, C8, C10, C11, C12, or C13. And then furthermore, even in looking at the assets where it's undisputed that they were marital, that is the wife's retirement accounts, the court used the wrong date. The court used the date July 29th, 2016, which is the date of the parties' separation. The trial took place in 2018. The opinion came out 22 months later in April of 22, and the law requires, the statute requires that the trial court is to look at the valuation of an asset as closely as possible to the date that the court gives its opinion. Here we have 6 years of change in value of those investment accounts. That's just a fundamental error, members of the court. The other thing that I think strikes me as so inappropriate, particularly in a day where we are trying to say we don't have to have traditional stereotypes of the woman works and the woman stays at home, the homemaker, she takes care of the children, and the man works. What we have here is, although the statute explicitly says in C2 that one individual's being a homemaker is supposed to be considered, there is no consideration whatsoever of that in this opinion. The trial court focuses upon the fact that the wife was the primary wage earner when the record reflects that the parties agreed when the second child was born in 2004 that he would become, the father would become the stay-at-home parent. There's no reflection at all that the trial court gave any valuation to that, any value on that at all. It was as if because one parent worked, that parent is sort of entitled to a priority status, if you will. So I think that is candidly the most deficient part of the opinion. I have a few seconds left. I will save the Wilkinson Pike property is the one last part, because that's on these other issues. I think it's a matter of we're asking for the court to remand, for the court to require the joinder of Judith Hill, and to require additional evidence with respect to the value of these assets at the appropriate time. But when it comes to Wilkinson Pike, which was the one piece of real property that the parties owned, what we're going to ask is the court, based on this record, make a determination that the trial court failed to apply the appropriate analysis and that it should be held to be separate property of the husband, not marital property. But I'll save that for my rebuttal.
Thank you, sir. Yes, sir.
Good afternoon, Your Honors, and may it please the court. My name is Alan Rawls with the firm Lowe, Yeager & Brown of the Knoxville Bar, here on behalf of the appellee, Mrs. Katherine Hill. I would agree with counsel for the appellant that there are several issues on this appeal to address, and so I would like to primarily focus on the two raised in his oral argument regarding joinder of Judith Hill as a necessary or indispensable party, and on the equitable considerations for division of property. First, the appellant argues that it was erred not to join his mother, Judith Hill, primarily based on this assertion that she claimed an interest in certain personal property, the cattle. The appellant's argument assumes that simply because someone claims an interest in some personal property at issue in a case, then that must be an indispensable party. But as this court recently noted in two cases, Locke v. Locke and Heiser v. McClung, there's a distinction between a necessary party and a proper party. So a proper party is someone who has a legal or equitable right in subject of the litigation, and is so connected with the dispute as to have a right or position with regard to the subject that entitles them to defend against the court's judgment. But as this court said in Locke v. Locke, only a party who will be directly affected by a decree and whose interest is not represented by any other party to the litigation is an indispensable or necessary party. So in Locke, the plaintiff in that case brought a detainer action against two individuals who were living in a mobile home on the plaintiff's property. That mobile home was owned by one of the defendant's mothers, who had been living there for several years. In affirming the trial court's conclusion that the mother was not actually a necessary party, this court reasoned in relevant part that any interest, quote, any interest the mother may have held in the disputed property was represented by defendants. The defendants asserted the mother's interests in the litigation, and because her interest was therefore adequately represented, her joinder wasn't strictly required under Rule 1901. And similarly, in Heiser v. McClung, that case involved a dispute between two competing boards of directors for a residential community club. The defendants in that case had moved to join all property owners within the club as necessary parties, and 21 of those property owners actually had moved to intervene, asserting that, in relevant part, that they were necessary parties under 1901. The trial court, and this court affirmed, ruled in pertinent part that there is no impairment to any of the interveners' ability to protect their interest because the relief which all of the interveners are requesting and the position which all the interveners are taking is identical to that of the defendants. If either party to the underlying suit can adequately represent the intervener's interest, then the intervention serves no purpose. And so the court agreed that the position of the interveners was identical, that there was an identity of interest with the existing defendants, and therefore, even where in that instance a non-party's interest may have been affected, if that interest can be adequately represented by an existing party, then the non-party need not be joined. Well, in this case, the appellant maintained that the 40 head of cattle, as you heard from Mr. Kelly, at issue were not his. He testified that they belonged to his mother, Judith Hill, and that he was merely taking care of them. And Judith Hill later testified as to, in part, why she was giving her son $5,000, $2,500, I believe, a month. I have to pay somebody to feed my cattle. Well, to the extent Judith Hill may have been asserting an interest in the cattle at issue, her interest was being represented by her son, the appellant, who was maintaining that those were Judith Hill's cattle. He maintained before and during trial that the cattle were not his, and therefore he and Judith Hill shared an identity of interest in this regard. The trial court correctly found, however, that the appellant held himself out as the owner of the cattle. He had purchased a $30,000 trailer for taking care of them. He was spending $1,500 a month during the winter to feed them, participating in regular upkeep for them, holding himself out as the owner and selling beef, and thus exercising possession of the cows. So based on the record and the relevant law, Judith Hill was at most a proper party whose purported interest in the cattle was being adequately represented by the appellant, Derek Hill, but she was not a necessary or indispensable party for this divorce action. Moving on, though, to the statutory factors, this issue that the appellant raises is effectively that the trial court's equitable division for marital assets was an error because it did not expressly consider all of the factors enumerated in Section 36(4)(121)(c). The appellant argues in his principal brief that while the court alluded to some of these factors, it did not consistently apply them and failed to consider many other factors at all. The difficulty with the argument, though, is that the code section at issue says in making an equitable division of marital property, the court shall consider all relevant factors, and then gives a non-exclusive list of those factors. Section 121C even includes a broad catch-all category of such other factors as are necessary to consider the equities between the parties.
But shouldn't, at least in order for our review, shouldn't the trial court have at least mentioned the statute and enumerated any of the factors? Instead, your argument is that she considered them by implication because she used some words that may match up with some of the words used in the statute, but she very clearly did not walk through the statutory factors. And doesn't that make it difficult for us to determine whether she properly considered those factors?
I think, Your Honor, that yes, it does make it a little bit difficult, that this isn't an ideal situation of clearly enumerating what statutory provisions were being relied upon. But to distinguish this from a case that's cited in the appellant's principal brief, Leonard v. Leonard, in that case, there was little to no substantive explanation of why the General Sessions Court, I believe it was in that case, did what it did. Instead, in that case, the trial court basically made a division of her personal property, vehicles, and bank accounts to each party, and made each of the parties responsible for the debts in his or her own name. Whereas here, in this opinion, while the statute is not specifically cited, it's possible, and here, the court can glean, as required under Rule 5201, what statutory factors were guiding the court's determination. And so, regarding, for example, consider the Abbott Hill property. So this was an 80-foot by 100-foot metal shop that had been constructed on land technically titled in Judith Hill's name. Now, the trial court made several findings of fact based on the evidence presented at trial, including that the parties constructed this shop during their marriage, the appellee, Mrs. Hill, substantially contributed financially to the construction of that building, that the appellant had misrepresented to her that the metal shop being built was on land owned by him, and that this building was supposed to be jointly owned for the benefit of the family. That, according to the trial court's order, this constituted dissipation of marital assets. They'd been using equity in their home to finance the structure. They'd been using the appellee's income to finance the structure, and that dissipated marital assets. It goes directly to the statute.
What about the retirement account? The retirement account is troubling for a couple of reasons. Number one, I'm not sure how the trial court came up with the amount. It doesn't match anything in the record. And I know you all have done a very sophisticated mathematical determination as to how she may have come up with that, but it's guessing. There's that problem, and then there's also the problem that she says it's a marital asset because it was accumulated during the marriage, but then she awards it all to the wife without any explanation as to why that marital asset is not divided.
Right, Your Honor. So as to the valuation issue, while we are of the opinion that that date, working backwards to the date of separation, was incorrect, the important thing here is looking at, say, a case like Owens v. Owens. There, the trial court did arguably something similar of engaging in some speculation as to what the value of I believe it was a co-tenancy in a home in Boca Raton, and valued that asset at, say, $20,000, when in reality, the proof showed that that value was for $97,000. Well, here, even just taking into account the evidence at trial, both parties had submitted that the value of the account was roughly $203,000 as of 2017. The appellee would submit that even given that amount, if this court were to take that into account, a remand on this issue is not required, because calculating that along with both parties' total net share of the estate is still equitable.
What was the total percentage breakdown for each side?
I don't know the percentages, but when we were engaging in determining the mathematical what it was, it came out, as I remember it, approximately $200,000 for the appellant and approximately $204,000 for the appellee. And as has been said in several cases like McPherson v. McPherson, unequal division of property is not inequitable. What matters is whether or not this court can glean from the opinion that, or the final order of divorce, that the court had determined the equities of the parties and divided it according to that.
Excuse me for interrupting, counsel. Before we leave the matter of the retirement, it appears from the trial court's final order that it valued that retirement as of the time of separation. Was that proper?
Under a plain reading of the statute, no, Your Honor. Looking at Section 121 B2. Counsel for the appellee would agree that all marital property shall be valued as of a date as near as possible to the date of entry of the order finally dividing the marital property. The position that we've taken in our brief and here today is that even taking that into account, it is not an issue that requires a remand because the division is still inequitable. The valuation may have been incorrect, but this court can address that in its opinion and not send this back to the trial court for even further protracted and acrimonious litigation. But as to a certain point that was made both in the appellant's reply brief and here today, it's implied that the trial court was supposed to go through a sort of a mechanical process of applying the statute in this case. Almost every consideration in Section 121C for different pieces of property. But even looking back at the Abbott Hill property, was it necessary to consider, say, for example, the duration of the marriage for that particular one? What the statute requires is a consideration of all relevant factors for the division of property. And so what matters in that situation is whether or not the trial court equitably considered the equities and properly divided the property. Given the rest of the time here, I would like to note that as it relates to the Wilkinson Pike property, the appellant argues that it was error to consider that marital property. But under the doctrine of transmutation and applying the case Hayes v. Hayes, the trial court correctly determined that while that property was gifted to the appellant in 1994 and was separate property before the marriage, throughout the course of their marriage, it became marital property. Hayes v. Hayes considers use of the property as the marital residence, ongoing maintenance and management by the parties, using credit of the non-owner's spouse to improve the property. And in applying that case, and even looking at cases like Lewis v. Lewis and Richardson v. Richardson, it is clear that here both parties were included on a HELOC and a mortgage. The appellee was paying that mortgage. They were drawing on this line of credit. They used it as their marital residence throughout the duration of their marriage. And so the trial court was correct in determining that that property had been transmuted into marital property. And there's nothing in the record to indicate that the presumption that raises with that is rebutted. If I may just briefly conclude, I see that my time is up. Regarding the remaining issues for this appeal, the appellee would just refer this honorable court. Obviously, you've read the briefs. Would just refer to the arguments raised therein. Thank you for your time.
Thank you, sir. Yes, sir, your rebuttal.
Your Honor. Members of the court, too, I do want to address primarily the Wilkinson Pike issue, but let me address a couple of points that were made regarding the statutory factors. I completely agree with what counsel said. Can this court, the standard is, can this court glean from what the trial court used to determine the equities of the parties? What do we have to look at? What is there in that opinion where this court can say, well, on this factor, here's how the trial court evaluated it. On this factor, how can this court, and that's the crucial thing under, of course, Rule 52, is the trial court has to make sufficient findings of fact that this court on that relevant issue can make a determination if it was based on the appropriate standard. We don't have that. I also agree with counsel that the trial court's only supposed to consider all relevant factors. Well, if these parties are not 65 and aren't on Social Security, then appropriately that wouldn't be necessarily the case. But look at the factors. If the court, there's crucial factors that were not mentioned. Number C2, the age, physical, and mental health nothing about that. Vocational skills, employability, earning capacity, estate, financial liabilities, and financial needs of each party. The tangible or intangible contribution of one party to the education, training, or increased earning power of the other. The relevability of each party for future acquisitions of capital. All of those matter. All of those should have been considered in the evaluation of what was equitable. Turning to Wilkinson Pike, the trial court erred. Commingling, the trial court mentioned commingling. I think if the court reads that opinion, it's clear there was no commingling. The fact that that personal property, a couch owned by the wife, was put in the house does not mean commingling. Commingling is where the property can't be segregated. Transmutation is a more challenging question because there's no question that under the first factor, the parties did live in the marital home for a substantial part of their marriage. But that's not the only factor, and as we pointed out in our brief, those other factors argue in favor of it being separate property, including the fact that it was owned by the husband before the marriage. It was a gift. It had been in the family. He did the work beforehand. But the fundamental error was the court didn't recognize that under the Langscript case, it only creates a presumption. Those factors only create a presumption, and a presumption that can be rebutted. And if I have one more minute, I promise, 1 second. And here, what do we have? We have the unequivocal statement, question of the wife to the husband, we ought to put this in both their names. And unequivocally, the husband says, absolutely not. And she never raises that again. Insofar as this transmutation doctrine is intended to look at the intent of the parties based upon actions and words, there couldn't be anything clearer. And I think for that reason, on that one issue, this court doesn't need to simply remand. This court should say, on this record, that was a separate asset. It should not have been a part of the marital estate.
Thank you, sir.
Thank you for your time.
I want to thank both the attorneys for your presentation. Your case has now been submitted to the court for resolution. You should receive our opinion and our judgment within a reasonable period of time. Thank you. You may be excused. Madam Clerk, will you recess court until tomorrow morning?